This quite extraordinary and very personal case. In the past hour or half hour or so, a High Court judge has ruled former Cabinet Minister and Auckland Mayor too, of course, John Banks, is the father of a man he's denied is his son for 47 years. Now, Antony Shaw took proceedings against Mr Banks last year after Mr Banks refused to acknowledge him as his son. Judge Patricia Courtney said, taking into account Banks's refusal to undergo a DNA test or engage in the legal process, she was prepared to make a legal declaration that on the balance of probabilities, Mr Banks is Mr Shaw's biological father. In the past few minutes, Mr Shaw released a statement. He says, "My case shines a light on a painful and shameful aspect of our social history. In the 1960s, the maternity wards of New Zealand hospitals were overflowing with babies needing adoption. My mother said she was going to have me adopted, but a home could not be found, so she kept me. How many thousands of New Zealand children suffered from being put up for adoption, and their mothers suffered from having to give them up? Mr Banks could have righted the wrongs of the past by taking responsibility now, and it is disappointing that he did not have the courage or courtesy to do so, and I was forced to go through this process. I am grateful that justice has been done in my case, and the decision goes some way to alleviating the pain and suffering I have gone through." Why did the judge reach the decision? On what evidence? Mr Shaw's lawyer is Jackie Lethbridge.
Well, in a case like this, as the judge has set out in the judgment, what persuades the judge is objective evidence. So things like letters, photographs, emails, testimony from different witnesses about the same matters of fact. And what the judge has done is looked at all of those factors and in the round decided that the balance of probabilities test has been met.
No DNA test, but the judge says, and I quote, "It is proper to infer from Mr Banks's refusal to undergo a DNA test that in his view the result would be supportive of Mr Shaw's claim." That is a very definitive statement from the judge.
Yes, it is. And so what the judge is drawing upon there is the test in Section 57 of the Family Proceedings Act. And that provides that while someone cannot be compelled to give a DNA test, in circumstances where you're making an application for a declaration of paternity, you ask them to have a DNA test. They could put the thing to rest by either by having it, and if there is a good explanation for why they wouldn't have it, which would be a definitive answer, that they're required to put that before the court. And in this case, Mr Banks did neither.
The result is only 2.5 lines long. It's one of the shortest judgments I've ever seen. It says, "I am satisfied on the balance of probabilities that Mr Banks is Mr Shaw's father. I therefore make the declaration sought that John Archibald Banks is the father of Antony Brett Shaw." Is that all Mr Shaw wanted? Simply that declaration?
Well, yes, that's the order that he was seeking. But while it might be the shortest order you've seen, the effect of it is actually wide-ranging. And the judgment is not just the actual finding. It includes that particular paragraph, it includes all the findings of fact that the judge has made. And she's taken quite some pages to, in careful detail, go through the evidence and make findings of fact.
So what happens now?
So what happens now is obviously the dust needs to settle a bit, but effectively steps will be taken now by Mr Shaw to have Mr Banks recorded on his birth certificate, and I mean that's really the only practical step that can be taken next. As for Mr Banks and Mr Shaw meeting or anything of that nature, that's something that obviously Mr Shaw will need to think about and approach down the track.
That's Mr Shaw's lawyer, Jackie Lethbridge.